Thank you so much to the Soho Forum, to the Smith Foundation, to the Reason Foundation. It's great to see you again, Gene. I wish I were there in person. Just to leave this not mysterious, I injured my knee playing tennis last week, and I actually need surgery on it. It's very hard to get around. My kids, if they were here, will tell you that it's a byproduct of my getting old. I kind of insist it's a byproduct of my athletic prowess. Maybe they and I can have a debate about that the next time the Soho Forum wants to debate. But in any event, I'm glad that we were able to make this work because I'm really looking forward to this debate. I think it's an incredibly important one. And I want to begin by doing something I'm unlikely to do for the next 90 minutes or so, which is I want to actually agree with something that Professor Foley said. And not just agree in passing, but agree quite wholeheartedly, which is she began, as I am, by saying that there was really nothing so shocking about the ruling in Trump versus the United States a few months ago, even though, as she said, it created this huge outcry in our political class. I agree that if you look at how the United States has developed judicially and politically over the last 35 years, really going back to, say, the pardon of President Nixon, it has unfortunately become part of our norms that presidents, in fact, are above the law, meaning that if they break the law, if they violate the criminal law while in office, they are not, in fact, treated like you are or anybody else is because they are shielded, or as the court called it, immune from prosecution, whereas nobody else in the citizenry is. Now, Professor Foley said, oh, that gets referred to as placing presidents above the law, which was the principal concern of the founders not to do. That we should not replicate the abuses of the British monarch and any other kind of monarch by putting people in one position vis-a-vis the law or other people in other positions vis-a-vis the law. We're all equal before the law. That was a foundational principle of the United States. But she said, well, you're not doing that because the law is that presidents are immune. Well, if that's true, the British king wasn't above the law either, because the British monarchy held, the prevailing law held, that kings cannot be held accountable under the law. So I think that's very semantic. Of course, it's the case that if you grant immunity, even for criminal violations, clear-cut criminal violations, and say that any citizen that breaks this one law here, everyone in the United States will be criminally prosecuted, but this one person, the president, is above that. He cannot be held criminally accountable. Then we are recreating the exact abuses of the British monarchy that the founders fought so hard to liberate themselves in a very dangerous and bloody war. And obviously the first thing on their mind was how to avoid replicating that when we create a centralized federal government to which all states and all citizens were bound. They were obsessed with that question. In the Federalist Papers, the Constitutional Convention, and every one of them, they all had different views about the extent of executive power. Alexander Hamilton believed we should have a very robust executive. James Madison, Thomas Jefferson were more worried that a robust executive would end up being more like the king. But all of them agreed and said explicitly that, of course, if presidents break the criminal law, impeachment's not enough. Impeachment in the Constitution is one way we get them out of office, but the Constitution itself and every founder who participated in the founding of our country emphasized that it's vital that presidents be held in the same status under the law as everybody else. Now, I want to just read quickly the resolution that we're actually technically debating and eventually voting on, because the question is not, did Trump versus the United States 3 months ago rule correctly, given precedents over the last 15, 20, 25 years that have created this very modern day immunity for presidents in other contexts, never in the criminal law before, but in other contexts. But that's not the question we're asking. Was Trump versus United States rightly decided? The question we're asking is, quote, presidential immunity for official acts is a key factor in the proper functioning of the US government's executive branch, the proper functioning. So it's not, did the court get it right legally in what was really its 5-3-1 decision because Justice Coney Barrett dissented in a lot of parts of the majority opinion. So that's not the issue. The issue is when we have a federal government and a republic, do we actually advance the proper functioning of the executive branch by holding that nothing a president does while in office relating to their official acts, even if it's a blatant crime, can ever be criminally prosecuted. And I would suggest not only is it not advancing the proper function of the government and the executive branch, it's actually destroying it. It's making it impossible to have a political system that inspires trust or that deserves credibility, because of course we're placing our political officials above the law. Now, let me just make a couple points, because of course it is the case that there were founders who wanted a strong executive branch. And as I said, Alexander Hamilton was probably among the founders, the most vocal advocate of that. Yet even he, in the Federalist Papers in Federalist 69, understood that although it's important to have a strong executive, it's at least as important, if not more so, to avoid recreating the king. And to do that, he said the following, quote, "The President of the United States would be liable to be impeached, tried, and upon conviction afterwards, liable to prosecution and punishment in the ordinary course of law." That was one of the ways Alexander Hamilton was emphasizing that although we're going to have a strong executive with a lot of powers shared by Congress and the judiciary, if he breaks the law, he's not like the British king, because after he gets out of the office, or if he's impeached, that's not the only remedy for violating the criminal law. It's also, as he put it, being prosecuted and punished in the ordinary course of law, talking about the president. I think it's also really important to note that the founders did actually debate the question of immunity, and Professor Foley actually referenced this. They knew how to give immunity if they thought that a particular part of the government should have it. And there's only one time they did it. And that was in Section 1, Article 6, where, as Professor Foley noted, the Constitution states explicitly that members of Congress have immunity for anything they say or do on the floor of the Congress in the speech and debate clause. So they knew what immunity was. They debated whether presidents should be immunized under the criminal law. They did not put that in the Constitution because none of them believed it. They did believe it. There should be immunity in this one limited sense, because otherwise you couldn't have a functioning Congress that was liable to be treated as criminal dissidents for things that they said on the floor of the Congress. So you could even have, for example, members of Congress go and read the Pentagon Papers, which Daniel Ellsberg tried to get them to do on the grounds that you're immunized. And that's because the Constitution gives immunity for that. It does not give immunity anywhere else. This is something we've invented out of whole cloth over the last several decades in something that has been very disturbing. Now, just to emphasize how central this preoccupation was until very recently with making sure presidents aren't like kings, I just want to say what I think is the most important precedent on the questions of the extent of presidential power and executive power, which predates most of what Professor Foley referred to. This is from the case of Youngstown Sheet in 1952. That was under the Truman administration. It's a very interesting case because there was the Korean War that was underway and that the United States was prosecuting. Obviously, we had declared it to be in our great national interest to win the war in Korea. And steel workers at major steel companies were threatening to strike, which would have had the effect of impeding our steel production and therefore impeded the war effort that President Truman under the Constitution was prosecuting. So you could argue there he was at his highest level of power. He's the commander-in-chief of a war authorized by Congress, and he's, in his judgment, acting to prevent the impediment of steel production because he wanted to seize the steel companies and put them under the control of the government for as long as the war lasted. And the Supreme Court said, no, you cannot do that. Even though you're the commander-in-chief, even though you might have immense national security powers under the Constitution, your powers are not unlimited. We don't have unlimited powers in this country. All powers are shared by Congress and the court. And what Justice Jackson said in his concurring opinion, which I think everybody would agree has become the most influential part of that opinion, he said, quote, "The example of such unlimited executive power that must have impressed the forefathers was the prerogative exercised by George III. And the description of its evils in the Declaration of Independence leads me to doubt that they were creating their new executive in his image." And that's exactly right. If you were to give full immunity of the kind Professor Foley wants to presidents, where she's really saying, as long as you're exercising whatever power under the presidency that you have, you can commit any crimes you want, no matter how blatant, no matter how egregious, no matter how ill-motivated, and you can never be prosecuted under any circumstances as long as you say it was relating to or in the exercise of your power, that would, of course, mean we're placing presidents above the law. Just to give you a really important example, because I think this is crucial to note that there are two different kinds of presidential powers. One is power vested in the presidency that is also vested in the other branches, particularly the Congress. So Professor Foley talked about what she called the virtually discretionary or wide power in foreign affairs. But as that Steele case noted that I just read, even there, the president's powers are limited. The Congress has the power to declare war. The Congress is responsible under Article 1 for raising the Army and the Navy. And so there's a lot of shared powers. Most powers are shared. There are only a couple of powers that are really reserved exclusively for the presidency, one of which is the pardon power. So under Professor Foley's vision of how the United States should work, you can imagine a case where a president says, I'm issuing a pardon, and the reason I'm doing so, and let's say they're doing it in the lame duck, like right now, and the reason I'm doing so is because I was bribed to do so. I was paid $1 million if I were to give this pardon, and I'm giving this pardon for $1 million. I was bribed. It's under the criminal statute. But because the pardon is one of my core presidential powers under the Constitution, in fact, it's one of the few that isn't shared with the Congress, it means that I'm free to exercise that power however I want, even if it's flagrantly criminal, and I will be immunized from prosecution afterward as a result of this immunity that the court 3 months ago and that Professor Foley is advocating. And if you look at everything the founders have said, I think you will find that it is a radical deviation from what they had in mind, and not just what they had in mind, but what they actually set out to create and to prohibit in what should still be our governing document, which is the Constitution and the Federalist Papers and debates around it that illuminate what it was intended to mean. Now, I say this is a very recent development, this idea that presidents should be immune even if they commit crimes, because it's actually the thing that motivated me to start leaving my profession as a practicing lawyer and becoming a journalist and wanting to have a bigger role in the public debate we were having about our politics and our law, because it was after 9/11 when I began to see that these very radical theories of executive power started to be promulgated under the Bush and Cheney administration. Dick Cheney was a longtime advocate of the kind of unlimited executive power that Professor Foley seems to support, at least to some extent. So much so that even going back to the Reagan years, when there was this scandal about Iran-Contra, where the Congress had prohibited the executive, the president, from using any funds of the United States to give to the Nicaraguan Contras to help overthrow the government, the executive branch ignored that and violated it and went behind Congress's back. They secretly sold missiles to Iran, got that money, and transferred it to Nicaragua in violation of congressional law. And the theories of why that was permissible that came from a then fringe group advocating presidential immunity was that, look, presidents are free to do whatever they want in foreign affairs, and not even Congress can limit them. It doesn't matter that Congress passed a law called the Bolin Amendment, banning us from giving money to the Contras. That's for the president and he alone to decide. And that was a very radical fringe view of what the American presidency was. And unfortunately, it really took hold out of exploiting the fears of 9/11. It's what I began writing about when the Bush Justice Department started doing things like torturing people, putting people in prison with no due process, with no opportunity to even have a single day in court of habeas corpus to contest their guilt, kidnapping people off the streets of Europe and sending them to Egypt and Syria to be tortured and interrogated, putting people in CIA black sites beyond the reach of human rights organizations and international conventions. And I think most offensively of all, spying on the telephone calls and other communications of American citizens without the warrants required by law. So Professor Foley said, oh, well, we've had this for 30 years now under Nixon, and the sky hasn't fallen. I think it's fallen. I think the Iran-Contra scandal was an incredibly egregious criminal violation that nobody was ever held accountable for, in part because of this idea of presidential immunity, but also because George Bush 41 pardoned everybody on his way out and therefore prevented any investigation from coming to his door. He was also obstructing justice, but the idea was presidents can't be held criminally accountable as long as they're exercising powers of the presidency, like the pardon. And that's why I use the more even extreme example that even if they were to admit they were bribed for it, under this immunity clause, they couldn't be. And I think the war on terror one is a great example. And this really did come from Richard Nixon. In 1977, after his presidency, Richard Nixon sat down with for a very famous interview with David Frost, the great television interviewer, the English television interviewer. And the thing people remember most about what President Nixon said, because it was so shocking when compared to people's understanding of what our country was supposed to be, was when he basically stood up and said what the court said and what Professor Foley is saying, which is, I am the law as the president. I can't be prosecuted for the law. I am the law. And this is what he said. David Frost asked the former President Nixon, so what in a sense you're saying is that there are situations where the president can decide that it's in the best interest of the nation or something and do something illegal. And President Nixon responded, well, when the president does it, that means it is not illegal. And then David Frost said, by definition, and Nixon said, exactly. If the president, for example, approves something because of the national security, or in the case because of a threat to internal peace or order of significant magnitude, then the president's decision and that interest is one that enables those who carry it out without violating a law. Now, a lot of the controversy from the war on terror came because Dick Cheney and Paul Wolfowitz were able to find people in the bowels of the Justice Department, very fringe radical lawyers like John Yoo, to write memos saying torturing people is legal, putting them in cages underground away from the human rights organizations is legal, so is kidnapping people off the streets is illegal. And that became very controversial. The Bush administration said, we're acting legally. We have these Justice Department memos. But if you believe Professor Foley's vision of America, why were those even necessary? George Bush and Dick Cheney could have just tortured away, could have spied on Americans with no warrants as they did, done any of that with no memos at all saying it's legal, and afterwards said, we can't be prosecuted. We're the president. We're above the law, the criminal law. Or in the words of Professor Foley, not above the criminal law, not above the law because the law says that the president is above the law and therefore that immunity is part of the law. So I think in theory, this is not only very dangerous and contrary to our founding, I think we've seen repeated instances over the past several decades of how dangerous it can be for presidents to first believe they're culturally or through political norms immunized for punishment when breaking the law and committing crimes. And even more so when we implement that tactically. And whatever else that is, if you look at the resolution we're debating, that is not the advancement of the proper functioning of the executive branch.